Hello, Harry. How are you doing? By now, I guess you've heard that the Supreme Court came back with their ruling on your case. I want to say that, first of all, I am sorry. We tried the best that we could. We decided to go ahead and file this case. You and I discussed this when we first began, that there were options that were open to you, and one of them was to take it to trial, and I followed your decision to take it to trial. But as we discussed, sometimes it happens that you get a ruling that is unpredictable, that a court does something that, we cannot predict as lawyers, as attorneys, and this sometimes happens. I also thought it was a bit unusual that the Supreme Court took the case to begin with. As you know, the state of Pennsylvania viewed you as a trespasser. And under the laws in Pennsylvania, you would not have succeeded if we had taken it to trial. That's why we filed it in the New York District Court. We took it up the federal level. We won twice, and a federal court awarded you damages. These damages were based on, of course, the 1842 Supreme Court decision in Swift v. Tyson. It ruled that federal courts sitting in diversity jurisdiction should apply federal common law to non-statutory causes of action. What that means in a nutshell is that, a different set of rules was used to determine the facts of the case in the lower two court cases where we had them in New York. They used a different set of rules, Harry. That's really what happened. The whole issue goes on, is Swift v. Tyson appropriate? And basically, it's not. The federal courts, they considered if there's a diversity jurisdiction, does the state law apply or does the federal law apply? In the past, they used the federal law, the federal common law, to determine jury awards, jury verdicts, etc. And unfortunately, in this case, the Supreme Court basically, they just decided, this is the issue that we have here, that no longer are we going to, in federal court, under diversity jurisdiction, apply federal common law to these cases. Now, they're going to apply the state laws. Of course, procedurally, it'll be a federal case. It's in a federal court. But they will use the federal law to determine who's right, who's wrong, who comes out on top. I can only apologize to you for this. We did the best we could. I discussed with you the risks. I told you there were inherent risks in taking this to trial, and had this not been appealed, you would have gotten your verdicts. You would have been paid. I can only apologize for what had happened. It's one of those issues where, we cannot predict this, but we also can't predict what judges do sometimes. Basically, there's always been a conflict between the government over state rights and state law and federal law. And, is there a separation of powers concerning the federal government and the states? That's really the issue that was at hand here. If we apply state substantive law, would it lead to more predictable outcomes for litigants and greater efficiency of the courts? That's what they decided. Thus, the court concluded that in diversity jurisdiction cases, the courts should apply substantive state law and federal procedural law unless there's a conflict between the state and federal law. That's what they ruled. It didn't go in your favor. There's not much we can do about it. I'm sorry for what happened, and, we discussed these possibilities when we had first taken the case. I wish you well, Harry. I hope that you find some good work and things go better for you in the future, but this is the final straw. The Supreme Court has decided there's no more appeals, and this is their decision. I wish you well. Godspeed.